Getting me? Okay. Testing, testing. Testing. Okay, we should get started. As you can hear from my voice and the microphone, I still got this cough. And here's what we're going to do today. Not too much reading again, although the additional reading packets were a little more substantive. And as I mentioned before, the readings will get longer, so don't get too comfortable with the short readings. You do want to allocate more time. Here's what we're going to try to cover. You know, up to now we've gotten through relevance as far as materiality is concerned, so hopefully you should have a pretty good understanding of materiality. And you have an initial understanding of logical relevance, but there's a particular point about logical relevance that I want to really expand on today, and that will be most of the first half of the class. And so what we're going to do is review logical relevance, and we're going to talk about that general fact that gets you from the evidence to what it is you're trying to prove. And you remember that the example we used of speeding 33 miles west of the accident, the general fact was the tendency for someone who's speeding at one point in time to be speeding at another point in time. And we're going to really focus in on how exactly do we want to word that general fact. Because what you'll see in the case of Dunkel is the court horribly misunderstands the principles underlying logical relevance and makes a number of logical blunders in its analysis. So we'll look at Dunkel and see how Dunkel messes up, basically. And it's always fun to make fun of courts because here we have the Pennsylvania Supreme Court. You know, these aren't untrained lay people. These are smart lawyers who've been nominated to the highest position in their state Supreme Court, and yet they don't get logical relevance right. So it's kind of a lesson for us all. We'll then talk about 104A and the preliminary assessment of evidence. Now, this might seem like a total detour to you because now we're going to switch to talking about the relative roles that the judge and the jury has. And what 104A and B basically does, it says, these are the issues that the judge decides, these are the issues that the jury decides. But the reason why we do it here is because 104B is the provision that applies to cases where you have a conditional relevance question. Now, something you may remember from last time, I said, you know, you can go from the evidence to what you're trying to prove either through general facts, that is that speeders tend to speed regularly, or specific facts. And specific facts would be something that makes you think that this person maintained his speed. Well, it turns out that conditional relevance is the rule that applies when a party can convince the judge that in order to go from the evidence to what you're trying to prove, you have to have some specific facts. When you have to prove some specific facts to go from the evidence to what you're trying to prove, that's a conditional relevance issue. And that's why I put 104A and B here under the topic of relevance. And we're going to look at Romano, which is, of course, the very sympathetic case of poor little 7-year-old Raina, who riding her brother's bike down the hill runs into a tree, suffering severe skull fractures, and of course a lawsuit follows. And you'll see how important the issue of conditional relevance is, because in Romano, the judge directed a verdict for the defendants. The plaintiffs were totally out of luck, and it was all because of a conditional relevance question. And then I'm going to get you ready for prejudice. And what I mean by that is get you ready to learn about prejudice, because I'm going to talk just a little bit about the issue of flight and guilt and the guilty mind material. You haven't read this yet, but the reason why I'm going to introduce it here is a really good understanding of logical relevance in Dunkel will help you to understand the potential for prejudice with the cases that have to do with flight and other evidence of a guilty mind. Okay, so hopefully you remember this slide from our last class. And this was the 90 miles an hour, 33 miles. And what we were trying to do is say, how can you decide logical relevance? And the way you decide logical relevance is you ask, well, what facts go from what you're offering to what you're trying to prove? What you're offering is the evidence of his speed before the accident. What you're trying to prove is his speed at the time of the accident. And here we mentioned that one way you might get there is just to make some general proposition, to say, well, it's a matter of common sense that speeders are going to maintain their excessive speed. And if it is a matter of common sense, the judge can find the evidence logically relevant and it can be admitted. So what I want to do is focus on this, how do you get from the evidence to what you're trying to prove, this issue, that speeders maintain excessive speed. And I want to reword it slightly to make it clear. But basically what we're going to talk about for half the class today, excuse me, is how certain must this statement be in order for logical relevance to be fulfilled, right? So let's rewrite it as speeders at point A, speed at point B, okay? The idea is that point A is that 33 miles west of the accident, or it could be any point west of the accident, and point B is the point at which the accident occurred. So I've switched out that language, and then I want to ask you, how certain must this statement be? And there's several different possibilities, okay? There's several different possibilities for the level of certainty that you have to reach in order for logical relevance to be fulfilled. One possibility is that speeders at point A always speed at point B. Maybe in order to be logically relevant, you have to prove that anybody who's speeding 33 miles west of the accident must maintain their speed. And only if that's true, can you offer this into evidence as being logically relevant. Now think about that for a second. Does that seem like the right standard? Or does that seem too stringent, perhaps? Think about other examples of logical relevance. So think about DNA identification. Remember, what do you get? How, you show that there's a DNA match, right? There's a DNA match. That is, that the DNA found at the crime scene is the same as the defendant's DNA. But in order to get from the evidence to the conclusion that the defendant was at the scene, you have to make the logical leap that a match means it's the same person. And that's a probabilistic assessment, right? That there's only one chance in 9 billion that someone coincidentally has the same DNA as the DNA left at the site, right? So you could say in that case, does the fact that someone has a match always mean that they were the person who left the DNA? And you'd say, no, there still is a 1 in 9 billion chance. There's some coincidental possibility. So you would have to reject DNA evidence as logically irrelevant if you use this standard, right? Clearly the standard can't be that speeders at point A always speed at point B. That's too stringent a standard for logical relevance. Okay, well, another possibility you might say is speeders at point A sometimes speed at point B. And stop and think about that for a second. Well, hopefully, that seems too lenient, right? And think about it this way. If the rule is simply sometimes, then couldn't I offer into evidence the fact that he wasn't speeding at point A in order to prove that he was speeding at point B? Because by this logic, I could say, we know sometimes people speed up. So it is logically relevant that he wasn't speeding at point A to prove that he was speeding at point B. If this were the standard, then you could offer anything into evidence. And you could say it's logically relevant to prove something else. So the sometimes is clearly too lenient. The always is clearly too stringent. Now, hopefully, these 2 points haven't been very difficult for you to follow, because very few people will say these are the standards for logical relevance. But what people will do is they'll say, okay, well, it's not always, it's not sometimes. You know, what comes to mind between always and sometimes? This is a popular alternative. Maybe it has to be the case that speeders at point A usually speed at point B. And you might even make your argument to the court for logical relevance in this way. You might say, well, most of the time, if you're a speeder, right, if you're a speeder, most of the time you're going to continue speeding. And you want to be really careful about making that argument, because that assumption that it has to be most of the time is part of what got the court confused in Dunkel when it evaluated the probative value of various symptoms of sexual abuse. Okay? So keep this in mind, but note that I'm going to have a problem with it, and consider this as an alternative. Maybe the logical relevance standard is that speeders at point A speed at point B more often than non-speeders at point A speed at point B. That's harder to say, which is probably why very few people initially move towards it. But notice that it's a little different, okay? It's not saying that most of the time speeders maintain their speed. It's that speeders maintain their speed more often than non-speeders. This would require speeders to maintain their speed more than 50% of the time. This would only require the fact that you're speeding to make it somewhat more likely. To make it somewhat more likely. Okay? Well, what is the standard for logical relevance? Remember how I said just learn the rules? Okay? If you just look at Rule 401, this is the embarrassing thing about getting old, so I can't read anymore. You have your books, right? You got your little books? Okay, class, please turn to Rule 401. Would anyone like to do a solo this morning? Okay. It says, relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. So more probable than without the evidence. Okay, does that look more like this? Or does that look more like this? Now, when we get the clickers, you know we're going to get clickers? Yeah, we're going to get clickers. And then you'll be able to, like, punch in what you think the answer is. And so no more solitaire, right? No more, I don't know what the heck you do when you're not paying attention. No more none of that stuff. You're going to be online all the time voting for the right answer, the wrong answer. And then the guy, Rick Lacey, says, you know, I can even help you so that you will know exactly which student said what. So if you say something wrong, you know, if there's one vote out of 150, I'll be able to go, boom, what are you thinking about? But we can't do that now. So hopefully a lot of you are saying, gee, that looks a little bit more like D. I hope that's what you're thinking. So these are the different possible definitions of logical relevance. Does it make X more likely than not? Notice that sounds a lot like speeders usually speed. So does the evidence make what you're trying to prove more likely than not? Does it make what you're trying to prove the most likely fact of all the different possibilities? Notice that's a little bit different, but it still says that it makes the conclusion more likely than other possible conclusions. Or does it just make what you're trying to prove more likely than it would have been if you didn't have the evidence? And here's where reading 401 gives you the clear answer. 401 clearly does not require that you have to make the hopeful conclusion more likely than not. It doesn't have to make it the most likely fact. It simply has to make the conclusion more likely than it would be without the evidence. Okay. So if we go back to our question, the answer is clearly going to be D. Now you might be thinking at this point, oh, well, this is why, you know, you're a law professor, because you learn to split hairs and make these fine distinctions that are difficult to understand and probably of no practical utility. Well, the first part might be true. The second part is not true. It has huge practical utility, because what happens in Dunkel is the court completely misunderstands logical relevance. It excludes evidence that should be admitted under the true standards under 401. It misapplies the standards of 401. And why don't we discuss that? Oh, you know what? Let me call up the panel. Okay, let me just give me a second. Geez, I can't even see the. Excel. Sorry, I should have done this sooner. Evidence, then evidence, PowerPoint, syllabus. There we go. Okay, there we go. Is Kyle Kincaid here? Kyle? Hi. Are you ready? Okay. Christy Kirksey? Hey, Christy. Shiri Klima? Or is it Klima? But it's Shiri. Okay, I'll call you Shiri. Michael Niffen? Do you go by Mike? Which? Either? Okay. And Charles Cool. Mr. Cool? Okay. And Ken or Kenneth Kronstadt? Kenneth? Ken? Okay, great. Okay. Let's see if I can do this right. There we go. All right, so let's talk about Dunkel. Let's talk about Dunkel. Here's what happened in Dunkel. The evidence, and I'm going to simplify this for you. It really wasn't clear what the evidence was because an expert testified in Dunkel about a whole bunch of different possible symptoms of sexual abuse. And I want to pick out one because it's going to nicely illustrate the logical relevance issues that I want to extract from this case. So let's assume that the evidence was that this child, who the prosecutor believes to have been sexually abused, has sexually victimized other children. And the prosecutor wants to present that evidence to suggest to the jury that this child has herself been victimized. Okay? And the issue before the court was, is this evidence logically relevant to prove that abuse occurred? Okay, so it's a straightforward logical relevance issue. And so if we go back to our chart, remember how in order to ask the relevance question, we say, well, what facts would allow you to go from the evidence to the conclusion? We look for some general fact. So to put it in terms of our current case, does the evidence that the victim sexually victimizes other children increase the likelihood of the conclusion, which is that the victim was sexually abused? Right? That's the logical relevance question that we're going to ask. And in order to answer that question, we have to ask, well, what allows you to go from the evidence to the conclusion? Okay? And here's where you have to really think carefully about this next step, is what kind of proposition allows you to go from the evidence to the conclusion? And if we put it in the way we put it when we first talked about speeders, we'd say, well, children who sexually victimize other children were sexually abused, right? If that's the case, then the fact that this child sexually victimizes other children proves that she was sexually abused. Okay. Now, we're going to pick apart that statement because putting that statement in too general terms is what leads to difficulties. I think it leads to difficulties with the court's reasoning. Here's what the court said. Here's what the court said. The expert testimony about the behavior patterns exhibited by sexually abused children does not meet this threshold determination of logical relevance. While it may bear upon a matter and issue, it does not render the desired inference more probable than not. Okay, now immediately, hopefully, you see a problem with the court's reasoning. So let's see. Kyle? You know, I'm sorry, I'll print out so I don't have to keep going back and forth to the Excel file. I'll print out a list later. Kyle, do you see a difficulty with the court's reasoning, something that it said about logical relevance that's incorrect? It's okay. Excellent. So Kyle says, it doesn't have to make the desired inference more probable than not, which would be like more likely than 50%. It only has to make the desired inference more likely than it would be without the evidence. Precisely. Remember the rule for logical relevance from 401. Okay? Whether the evidence has any tendency to make the hopeful conclusion more probable than it would be without the evidence. Not, oops, I shouldn't put that red bar over there so quickly, whether the evidence has any tendency to make the desired inference more probable than not. So what is the court saying? So the court, if I said to the court, okay, this child's been victimizing other children, what would the court want me to be able to prove in order for that statement to be logically relevant in order to prove she was sexually abused? That always, well, it wouldn't have to be always. More likely than not, wouldn't have to be necessarily, but usually. Yeah, it would basically be a usually standard, that most children who victimize others have been sexually abused. And if I could prove that, then they would allow me to prove that this child had victimized others. Yeah? That's right. The court's saying that if it's many, that's not sufficient. And what you want to think about is, does that seem right? Because that's actually the road to the error that the court makes. As many is not enough, right? And this issue of more than it would be without the evidence, we want to make sure we see the distinction between that and either many or most or all. Okay? Yeah. Right. Now, this annoying tendency of students to jump way ahead. You've done it. That's great. But as you pointed out, and what's your name? Alma. That what you want to do is compare children who have been abused to children who haven't been abused. Okay, that's excellent. Now I want you to immediately forget that so that I still have something to say for the next 15, 20 minutes. But that's exactly right. That's going to be exactly right. But let's make more fun of the court before we jump to the answer, okay? I love making fun of these guys. The court refers to this study, and it's Kyle. Yeah, okay. I brought name tags and magic markers that will help me a lot with learning people's names because I'm terrible at names. But we'll hand those out over break. Okay, so Kyle, here's the study that the court referred to. Now, it's interesting to stop and say, wait, there's a study. If you think about logical relevance, most of the time the court just uses their common sense. And this is one of those cases where a little knowledge is a dangerous thing. I think the fact that the court was confronted with a study led the court to get more confused about the percentages and what the percentages really mean. Okay? And part of the problem is the court is thinking about, if a child is victimizing others, what is the likelihood that they've been sexually abused? But what the study tells them is if a child is sexually abused, what is the likelihood that they've been victimizing others? And that inverse statement that I just made, we're going to talk a lot more when we talk about probabilistic evidence. It creates huge amounts of confusion. So part of the problem here is that there's a study and the court has to think about it. And if the court could just be commonsensical, it probably, it less likely would have made these mistakes. So here's what the study says. The study was a study of children we know were abused. And these are the percentages of different symptoms. And I've just picked out a couple just for us to think about, okay? So So notice, what's the most common symptom of any of these? This is an easy one. Yeah, nightmares. Right. It's when it's too deceptively easy, then you're afraid, right? Because you're thinking, uh-oh, something tricky. But it's nothing tricky. The nightmares are the most common. Daydreaming is quite common. Notice that sexually victimizes others is actually very rare. It's very rare. What does the court make of these percentages? Here's what the court says. The court, and you want to imagine this Supreme Court talking, for every symptom that was exhibited by any percentage, an even larger number do not exhibit that symptom. And not only that, but not one single symptom was exhibited by a majority of sexually abused children. Clearly, these types of percentages cannot constitute probative evidence. And I don't know if we've used the term probative. I just kind of throw it around. Probative evidence means evidence that proves a material fact. It's evidence that's logically relevant. Okay? Court says this is just so obvious. They don't even have to explain it. But can you see something wrong with the court's reasoning?
Yeah, numbers could constitute probative evidence if
Yeah, which is Alma's point. So you're getting at the same thing. So these numbers could be logically relevant. It depends on how often non-abused children exhibit these symptoms. Let's pick apart the court even further. The court thinks it's saying two different things here. Okay? When the court says for every symptom that was exhibited by any percentage, an even larger number do not exhibit that symptom, what do they mean? How can you turn that into numbers for the percentage of children who exhibit a symptom? Yeah, so no symptom was exhibited by a majority, so that would mean any symptom is going to be less than 50%, right? Yeah, so right, because it's just going to be, it has to add up to 100%. So if it's 40%, then an even larger number do not exhibit, 60%, yeah. If it's exactly 50%, you wouldn't say an even larger number do not exhibit. So it has to be exactly less than 50%. So any symptom less than 50%. The court says, but that's not all. Not one single symptom was exhibited by a majority of sexually abused children. Now what are they saying? Not one single symptom was exhibited by a majority. So they're saying any symptom, it's the same thing. Well, it's actually, you could say it's less than or equal to 50. They're saying the same thing. The court's saying the same thing over again. I've got 2 points to make, right? Numbers confound. That's the real scary thing here. It's very simple, but the court starts getting confused. Okay, but the basic point is this point about what's the percentage of non-abused kids. Okay, so let's play the game. Can a symptom be exhibited by a minority and still be relevant evidence? So the example is only 3% of abused children sexually victimize other children. What additional fact would make that relevant? Right, if less than 3% of non-abused children sexually victimize other children. Did the study say? Didn't say anything about it. So in some ways you can say the study is incomplete. Maybe the court could have said, you know what? We don't have the necessary data to make a decision about logical relevance. That would have been a certainly more scientific, more intelligent way to approach this data. Why do you suppose the person presenting the evidence didn't think they needed to present the percentage of non-abused kids who do these things? Pardon? Yeah, maybe they don't understand it either. Or they think that it's commonsensical that these are the kinds of things that are very rare in non-abused kids. One of the problems with when sexual abuse was first starting to be diagnosed a lot more than it had been is experts would come into court and say, oh yes, the child has all the symptoms. She's wetting her bed, she has nightmares. And the problem is they didn't know that these are terribly typical symptoms of all kids. Amazingly enough, the people who were treating kids didn't know what normal kids looked like. And they would make the error in the opposite direction. They would think things were probative when they weren't, in fact, of any probative value. Now, to make sure we totally understand this, let me give you an extreme case. So assume that 3% of abused children exhibit this symptom. They victimize others. And none of non-abused children do so. If I then give you a child and I say, guess what, this child's been victimizing others, what can you say? Absolute certainty, right? Absolute certainty. So the percentage of abused kids who exhibit really in some way has nothing to do with probative value. It could be 0.00001%, but if it's unique to abused kids, then it's conclusive evidence that abuse occurred. And this is actually the case. So gonorrhea in young children is conclusive evidence that the child was sexually touched. For years and years and years, doctors entertained the toilet seat theory because they would have kids coming in with venereal disease and they just couldn't believe that abuse was occurring. So they developed this alternative theory of transmission that they laugh at today. Okay? But it's very rare, yet highly probative. So you would be absolutely certain because only abused children victimize others. Okay? And then, of course, the opposite can be true, right, or the converse. Can a symptom be exhibited by a majority and not be probative evidence? Yeah. Right. And in fact, if more non-abused kids exhibit the symptom, then what happens? That's right. Then it's evidence that the child was not abused. Okay? So, assume that 80% of sexually abused children report being afraid of the dark. Well, it's probable that at least 80%, if not more. So it might even be being afraid of the dark is evidence that you weren't abused. Okay, sorry, I went a little too fast through that. Okay? Okay. So, back to what Kyle had said once and Alma said before, and we'll say it again. When is a symptom relevant? When the percentage of abused children who exhibit the symptom is higher than the percentage of non-abused children who exhibit the symptom. Now you want to stop and think about that and say, okay, so I'm not going to be talking about sexually abused kids in any cases. I'm going to be talking about other types of evidence. So when the percentage of speeders who continue speeding is higher than the percentage of non-speeders who continue speeding. Now, Kyle, given that, what do you think? Does that sound logically relevant? That someone was speeding 33 miles west of the accident? Does that make him slightly more likely than if he hadn't been speeding to be speeding at the time of the accident? It seems so. And when you really understand logical relevance, you realize that most everything that has even some slight tendency to push you in the direction that you're inclining is going to be logically relevant. It is a very, very, very lenient standard. And to the extent that you're bothered by things that do not seem relevant enough, you can't rely on logical relevance to exclude them, but you will find out that you can then move over to prejudice. Because prejudice will allow you to say, well, it's a waste of time. It's this such slight probative value. Or you can say, well, the jury won't realize how insignificant it is. If an expert comes into court and says, this child has nightmares, and you can prove that it slightly increases the likelihood of abuse, you might still say we should exclude it because the jury will say, ooh, an expert. They said the child's having nightmares. I guess that means she was abused, right? The jury might misuse it. But that's not logical relevance. That's going to be a different issue. Yeah.
So I was just going to say that if we're saying, for example, 80% of non-abused children are afraid of the dark, let's say abused children, only like 20% are afraid of the dark.
Right.
And you might be able to use that, couldn't you, and say that that is evidence
Of non-abuse. Right. That the fact that a child was afraid of the dark would now make it more likely that they fell into the non-abuse group. Is that what you're asking?
I'm just saying that, say, a kid then
Yeah.
is not afraid of the dark.
Okay. So if they're not afraid of the dark, under your conditions, that would suggest that they were abused. Yeah, so a fearlessness in the face of darkness would be a symptom of abuse. Right. And ironically, if a child is highly sexualized, right, that can be evidence of abuse. If a child is very fearful of sex, that can be evidence of abuse. So you do get sort of paradoxes with the symptoms. Now, go back to this statement. Part of the problem with this statement is that it's deceptively close to an incorrect statement. It's deceptively close to this statement. When the percentage of abused children who exhibit the symptom is higher than the percentage of abused children who do not exhibit the symptom. Right? Notice how similar those look, but they're quite different. And in fact, if we go back to what the court was doing, where it was playing with these 50% figures, can you see why it might have thought this? Right? That's what it's complaining about. It's complaining about the fact that that none of the percentages are greater than 50%. And since none of the percentages are greater than 50%, the percentage of abused children who exhibit the symptom is never higher than the percentage of abused children who do not exhibit the symptom. I think that's what creates the error for the court. So you have to make sure you understand the difference between this and this. Okay. All right, any other questions? Okay, so to make things painfully clear, because as soon as you walk out the door, forget. The general fact, how certain must this statement be? If you had your clickers, you would know the answer. Right? Everybody would choose C. No, everybody would choose D. That's the standard for logical relevance. And that's the standard that court misunderstands. It's funny because Pennsylvania, ever since that opinion, has been much harder on this type of evidence in abuse cases than other states. They basically said, we put our foot down in Dunkel. You could say they put their foot in it in Dunkel. And we're not going to take that foot out. And so, a logical error can mean a lot in terms of misunderstanding the rules of evidence. Okay, so that's all we're going to talk about for logical relevance. Now let's shift to the second topic for today, which is Rule 104. And again, I'm going to give you the language of the rule, but tell you the skinny version, the thing you want to have, make sure you have in your notes. Here's what 104A. Oh, and let's see, do I have any questions about 104A? Yeah, when I get to Romano, I'll call another member of the panel. So here's the rule. Questions of admissibility generally. Preliminary questions concerning the qualification of a person to be a witness, the existence of a privilege, or the admissibility of evidence shall be determined by the court. And here's what you want to write. Witness qualification, privilege, admissibility determined by court. Now, this is kind of obvious. I mean, you probably already intuit this. This is what the judge is going to decide. And you already know a little bit about privileges because I introduced you to them the first day, and you've heard of attorney-client privilege already. Witness qualification. There used to be lots of witness qualification rules of competency. I don't teach any of them because really they don't exist anymore. There's a little bit of child competency issues that I'm personally interested in, but I don't think worthy teaching because it doesn't come up that often. The major witness qualification issue that you'll see is experts, whether someone qualifies as an expert as opposed to a lay witness. Because if they're an expert, they're allowed to say things that lay people can't. They're allowed to speculate a lot more. And then that admissibility of evidence shall be determined by the court, but that has a qualifier. So notice you don't have a period at the end of this note. because it goes on to say, subject to the provisions of subdivision B. To make it easy for you, here's what you want to write. The admissibility of evidence unless the preliminary question is conditional relevance, in which case B applies. Okay? Unless the preliminary question is conditional relevance, in which case B applies. Okay. Now the court, the rule goes on to say, in making its determination, it is not bound by the rules of evidence except those with respect to privileges. Now this might be weird. The rule is saying that the rules don't apply. Okay? Well, obviously, the rule isn't saying that Rule 104 doesn't apply. But what rules don't apply? Well, here's the way to think about it. The court can consider any unprivileged information in deciding whether evidence is admissible. Okay? And this is going to come up a lot. This is sort of a tricky issue. The court is not bound by the rules of evidence in applying the rules of evidence. When the court is making a preliminary determination, it does not have to limit itself to things that the jury could hear. And one way to understand this is to remember that in these preliminary determinations, the jury is often excused. So when the jury goes out, let's say it's an expert witness qualification issue, you may have evidence that the expert is qualified. You might have a resume or a vita. Well, that resume or vita has all sorts of hearsay and best evidence problems, as you'll learn. But because the jury is out of the room and the judge is making a decision, the judge is not bound by the rules of hearsay and best evidence in deciding whether an expert is qualified. Okay? Notice, though, that the judge still is bound by privilege. The judge cannot make a preliminary determination of admissibility based on privileged information. Now, when the court makes decisions about whether a privilege applies, you might say, ooh, that's tricky, because the court can't even look at it in order to decide if it's privileged or not, right? Well, it turns out the court can look at it, but the court can't use privileged information in making a preliminary determination. Okay. So that's what the judge can do. But the reason why we're talking about this today is the jury gets to do something else. And that's where you have that except when there's a preliminary question about conditional relevance, in which case the jury decides. And that's what gets us to 104B. Oh, and quick note to you. A lot of times later in the semester I'll say, is this 104A or 104B? And what I mean is this a judge decision or is this a conditional relevance decision that the jury will decide? Because actually it's sometimes hard to know whether it's a 104A or 104B. And you're really getting good with evidence, people, when you use numbers that way, right? You say, oh, that's a 701 question, and everyone nods and smiles. So it kind of gets you into the club. So I'm going to get you into the club right now. Okay. B, relevancy condition on fact. When the relevancy of evidence depends upon the fulfillment of a condition of fact. And what you want to write is, when evidence is conditionally relevant. Okay, that's what this means. Relevancy of evidence depends upon the fulfillment of condition of fact. When evidence is conditionally relevant, the court shall admit it upon or subject to the introduction of evidence sufficient to support a finding the fulfillment of the condition. Right. There must be, quote, evidence sufficient to support a finding, unquote, of the precondition. There must be evidence sufficient to support a finding. Okay. So, of course, your first question should be, well, when does the relevancy of evidence depend upon the fulfillment of a condition of a fact? When is conditional relevance an issue? And that's our next question. So when does the relevancy of evidence depend upon the fulfillment of a condition of fact? And the answer is actually quite simple, partly because I set it up when we talked about going from E to X, right? When we talked about determining logical relevance, we said, how can you get from the evidence to the conclusion? Well, you can get there through general facts about the world, common sense, Speeders tend to maintain their speed, and now we know more precisely. Speeders maintain their speed more often than non-speeders. Common sense, judge knows it, judge lets it in. But let's say the judge doesn't know. The judge says, well, I don't know. I need some specific facts. I need some specific information to allow me to go from the evidence to what you're desiring to prove. If that's the case, then you have a conditional relevance issue. So conditional relevance applies when moving from the evidence to the conclusion requires an inferential leap, right? When it's a logical relevance issue, but a particular kind of logical relevance issue, where you must have specific facts, which must be filled by facts specific to the case. Okay. Okay, so recall the inferential leap in assessing logical relevance that we dealt with last week. This was the evidence, this was the conclusion. The inferential leap has to be that the speeders maintain their speed. And notice that speeders maintain their speed is just a general statement that you would make. That would be an issue of common sense for the judge to decide. And if the judge thinks it's commonsensical, the judge lets it in. There's no question. But the opponent might say, wait a minute, in order to make that inferential leap, it depends. It depends on whether certain facts about this evidence are fulfilled. And if the opponent can convince the judge that you really don't know if it's logically relevant, unless those specific facts are fulfilled, the opponent has turned a logical relevance question into a conditional relevance question. They basically added a requirement to the rule of logical relevance. And you might say things like this. You might say, well, was the road the same, right? He was speeding here. He was going 90 miles here, but it was on an open stretch of freeway, and the accident occurred at a busy city intersection. So just because he was speeding out on an open road doesn't mean he was speeding here, right? Was the defendant the same, right? Oftentimes we exclude evidence because it's ancient history, because it's too long ago or too remote, or the defendant was in different circumstances. And we say, therefore, it's unfair. And whenever we say that, whenever we say the logical relevance depends on that conditional fact, then we have a conditional relevance issue. And then the judge has to stop and say, okay, is there evidence sufficient to support a finding? And that's itself a question. But let me show you the whole chart then, right? Remember, we had two different ways to get from the evidence to the conclusion. In a conditional relevance case, it's the specific facts that we have to find. Okay? In a conditional relevance case, it's the specific facts that we have to find. Okay. So it's about 11:30. Why don't we take our break until 11:40, and then when we come back, we'll look at Romano, and I'll call up the rest of the panel. So, and actually, let me ask you something. Could you please, do I have my clock here? Let me put the clock up, and let me ask you to do something for me. Or maybe the best way to do it is, why don't we hand this out? I'll just hand it out when we come back from break, but I'm going to ask you to make name tags. And what you do is you fold them lengthwise, and you write magic marker. I'm going to pass magic markers around, and then you just put it in front of your laptop or in front of yourself. And I'll put one in front of me so you don't feel shy about having a name tag. And thing is, put it in your book or put it in whatever you bring to class, because if you really keep bringing it, I end up learning, pretty good percentage of the students, and it's really nice to know your name. So I'll hand these out when we come back from break, 11:40.
is theoretically able to signal what he wasn't supposed to hear. First name, last name is good, actually. Hi. I don't know if this is like evidence or rule report or what, but I'm looking at the DA's office in Compton at the Hartford Game Unit, and so I hear like all sorts of crazy stories. I think going on off the crazy stuff. I'll bet. That must be fun. Oh, do you have a pen I could borrow? I guess with the laptop, you don't even need to get the pen. That's right. Old school. Okay, thanks. Come back up. How long have you been working there? So one day I went in and there was a feeling about the site for a guy who's in custody for witness intimidation and safety. Yeah. Okay. When the DA has someone on trial for standing over, and they not only have to prove murder, but he wanted to prove that the guy was wrong. Right. When they originally was about to take the stand, some guy, a gang member, walked into the courtroom wearing all blue and like a blue hat that said like CP. Oh my God. And standard to intimidate the witness, right? And the DA sees this guy come in, and so he goes, like, why is he going to go I call him to the stand? And he calls him to the stand, and the defense objects. He says, what the hell are you doing? And he's like, well, like, look at the way he's dressed. He looks like he's buddies with the defendant. Yeah. I put him on the stand. I could prove that that guy's in the game. And the judge let it go. But it seems very, I don't know anything about this, but it seems right. Is that cool? Yeah, I mean, it seems pretty bright on the part of the DA. Do you know whether he got any admissions out of it? Okay, so the story itself is good. So the guy gets up on the stand, right? And the DA asks him, what is the CP? The CP testifies the part. So what is the CP on your back passport? And the guy goes, Carolina, Kansas. And the whole courtroom starts erupting laughing, right? And then he goes, are you in the gang? And the guy goes, no. And after all this stuff, the guy takes a joke out of it. He gets down off the stand, and then he makes a threat to someone. He like, we're actually threatening someone. And I guess the DA and or bailiff or someone heard. Oh my God. They had him arrested in the courtroom. Wow. And then when they arrested him, they took like photographs and stuff. And he had no game tattoo. He had the tattoo, he told me what it was. And that tattoo's a no game tattoo. So he was up there and said, I'm not in the game. I have no game tattoo. So that's the perjury. Right. And witness intimidation. And I was there for the prelim, and they plea bargained, and he got 16 months in jail. Like this idiot, he just like drove to court. Wow. Like I saw him get like. Wow, that's interesting. Yeah. So the DA told me the story, and he's like my adrenaline was pumping, and I saw him stand, and I was called him to the stand, and let it go. Right. But anyone there, you can call to the stand. I think that's right. I mean, the weird thing about it is, the argument I'd make on the defense is that it's not relevant to the guilt of the defendant. It might be relevant to issues of if the person turns out to be unavailable, but that's a preliminary determination. So I say this is the kind of thing that should be heard by the judge outside the presence of the jury. Isn't it relevant to what one of the counts is the fact that he's in a gang? Yeah, to prove his gang affiliation. But could he prove a connection between this guy and the defendant? The way he's dressed. Well, but I mean, but the argument the defense would make is that if he doesn't show that this guy is connected to the defendant, then it becomes prejudicial because any gang member is going to look at it as this. But you're actually right. I think that it's close enough to being relevant to prove his gang affiliation, because you could say the fact that he comes into the trial suggests he has a connection to the defendant. Then it probably would be admissible. So don't you have to get a list of witnesses or way before? Yeah, well, but that's always subject to change. So the defense could say, I wasn't prepared, and the judge would say, well, fine, I'll grant you a continuance before you cross-examine. It would be very rare for the judge to not allow them to introduce a witness. Oh, really? I supposed to know this guy was going to come in? So if it's not unfair, they allow the witness and then they give the other time more time to prepare. Yeah, that's really interesting. Yeah. Oh. Wait, so you're saying... Right. Right. Oh. Well, yeah, the error was the defense attorney shouldn't have argued in the alternative. She shouldn't have said, assuming the girl really did tell her mother, she was being irresponsible. Because then it doesn't really undermine the credibility of the abuse allegation. It only prejudices the jury against the mother. So the defense should have said, I believe that she never told her mother at all. And the fact that she sleeps with her after she claims she told her undermines the credibility that she told her in the first place. So it's kind of weird. It's like you have to imagine the state of affairs that you think occurred in order to argue logical relevance, right? So the defendant attorney should have just stuck to that one. That's right. That's right. And it's kind of a general theme that says when you're the defense, you present a single coherent story and you keep with it. And that's always going to be more persuasive than these alternative theories. I think this is okay. Thank you. Yeah. There's little Gould book. Yeah, here's my first one. Oh, you need one? Yeah, I got more. Oh, you're welcome. There you be. All right.
Okay, we should get back to our seats and get started. So I'm going to hand out the what's the best way to do this? I guess I'll give like three magic markers, and then a bunch of the sheets, and you can start making name tags. See, another third, or actually I guess I could give more than the third to the middle group. I think I have 150 here. Okay, there you go. Now I'm a little worried. I don't have as much material today as I thought I did. So if we end early today, I'm going to ask your indulgence and ask you to come back to get your clickers, because the clicker man, Rick Lacey from the it's Technology Enhanced Learning Group at USC. They're going to come shortly before 12:20. But we'll see. We'll see how much discussion we have. Here you go. Oh yeah, if you could, I think actually it's best to put your first and your last name, because then I often remember both. Okay, and let me ask: is Christy? Christy, that's you. Okay, Christy, let's look at the Romano case. And here's what happens in Romano. The Raina, 7-year-old Raina, is riding her brother's bike down the hill, and she fractures her skull in a bike accident. And the parents claim that it was a defective brake that caused her injuries. Okay, and this is actually the evidence in issue. Is a man named Mandel, an engineer, examined the brake 2 years after the accident and found that the brake was defective. Okay. Oh, I've never noticed the sound, that squeaky sound. That's kind of a sweet sound of magic markers against paper. And here's what happened before Mr. Mandel got a hold of the bike. A 175-pound guy, his weight is not usually relevant, but it's kind of relevant here, tested the brake 40 times by putting a 50-pound weight and testing whether or not the brake would fail 2 weeks after the accident. And did he ever have any brake failure when he tested the bike? No, it never failed. And since Kostras's experiments, the bike was in storage in the parents' basement. Okay. Now, this next sentence is in my slide, but I was rereading the case, as I try to do. And I have here, court excludes Mandel's testimony under 104B. Is that actually correct? Yeah. Well, that's a rhetorical question you're asking, right? They didn't apply 104B. They said, oh, there's this new rule. It's always funny to read these cases that come out shortly after. There's this new rule about conditional relevance, but nobody can make any sense of it, and it's just ridiculous, and we're not going to admit it. But can you why do I teach it if it doesn't apply 104B? Well, it's as good as applying 104B, right? Can you take what the court did and turn it into a conditional relevance issue? So can you state for us, the court decided that conditional relevance was not met in this case. Oh, okay. Well, let me say it a little bit differently. Why did the court not let Mandel testify? What was the court concerned about? Yeah, the bike may not have been the same. So if the bike wasn't the same, then how did that undermine Mandel's testimony? Well, what does the defense say? Does the defense acknowledge that the brake was defective at the time of the accident? Yeah, just think practically with me here. Don't worry about the rules. Wait, the defense doesn't want to say the brake's defective, right? So what is the defense theory of the case? If you're the defense, you're saying we make good bikes. We do not sell defective brakes. So who do they blame the defective brake on? No, they don't blame the girl. Never blame a 7-year-old girl, especially one with a fractured skull. She comes into court, she's got the cute little, everyone signed her head because she's got that big bandage. Don't blame the girl. Who do you blame? Yes. You said two things that were both correct. You need to be a little more confident in yourself. But you said the guy who tested the bike, Costerus. That's why the fact that he's 175 pounds is important. This big, 175 pounds is actually not that big, but we'll say this big brute, right, gets on top of this little kid's bike, adds a 50-pound weight, and rides it down the hill 40 times, and now the brake is defective? Hello, right? That's what caused the brake. And what else might have caused the brake to have become defective? Yeah, it's been sitting there in the garage collecting dust for 2 years, and so dust may have got into the braking mechanism. Since we know the cap was off, right, so there's this hole in it. So basically what the court concludes as a factual matter is I don't know if the brake was the same 2 years ago, and therefore I'm not going to allow Mandel's testimony. Okay, so that's just the way to think about it factually. And that's always the way you think about it first. It's just what's the argument that makes sense to a jury. But in order to get the judge to exclude this entirely, you're going to have to turn it into a rule of evidence. You're going to have to say we can exclude it as a matter of law. And that's where conditional relevance comes in. So we can use our little timeline. Remember we used the highway? We can use it as a timeline now. So the evidence is the brake was defective when Mandel tested it. Before the evidence was over here because it was west of the accident, but here we'll say the evidence is here because it's now. And what you're trying to prove is that the brake was defective on the day of the accident, right? How do you get from the evidence to the conclusion? Do you have to make an inferential leap? And what is the inferential leap that you have to make to get from the evidence to the conclusion? Yeah. The inferential leap. Is that whether the bike remained the same, and then more specifically, did Costerus mess with the bike? Right? Did he change the bike? Did the storage affect the bike? These are all preconditions, you could say. So if I said to you, is Mandel's testimony that the brake was defective logically relevant? In other words, does his testimony that the brake was defective increase the likelihood that the brake was defective when Raina rode down the hill? You'd say, well, it depends. What does it depend on? It depends on if the bike remained the same. It depends on whether storage changed the bike, whether Costerus changed the bike. Now notice you could say, well, you just have some common sense about whether bikes change over time. That would be a logical relevance problem. But notice that you're asking specifics about the facts of the case. We need to know what happened to that bike. We need to know exactly what Costerus did to that bike. And only if we can prove that Costerus did not change the bike or that storage did not change the bike can we find the testimony to be logically relevant. And since we're asking for specific facts to make that inferential leap, it's a conditional relevance issue, okay? So in order to go from the evidence that Mandel found the brake defective to the hoped-for conclusion, which is that the brake was defective when the accident occurred, we have to ask, what facts would allow you to go from the evidence to the conclusion? You're saying, now this is the trick, you have to convince the judge that you need to know, right? You're saying we really have no idea of the relevance of this testimony unless we know this. that the break remained in the same condition for 2 years, and then you say, well, what facts allow you to go? I mean, what is the evidence? What does the evidence prove? Is there evidence that the condition of the break had not changed? And that's why the court, outside of the hearing of the jury, although as you'll see it doesn't have to be outside of the jury, the court hears the evidence, is not convinced, and decides that the evidence has not come in. Now the court says we're not applying 104B, we don't believe in conditional relevance, because it was generally believed that 104B was relaxing the rules, was increasing the ability of the jury to hear more evidence, and the court was resisting that. But even if the court had been forced to apply 104B, the court could legitimately attempt to do so using the standards of 104B. Okay? Now, one question that you might ask is you might say, well, wait a minute, there's always a conditional relevance issue. And that's what this little question is at the end of the additional reading packet. Think about Ball's argument, and this is Ball's quoted in the court case. He was a leading commentator on this issue, that there's a conditional relevance issue behind every tree. How does this make any sense? How can we say there's always a conditional relevance issue? Can I open it up to anybody? Oh, wow, the name tags are all up. Is everybody done? I guess we're almost at the end. Yeah. You can always think of another fact that would make that fact relevant or irrelevant, right? So, okay, so let me give you an example. So 33 miles west of the accident, how is that a conditional relevance problem? I prove that you were speeding 33 miles west of the accident. You say, well, that doesn't prove I'm speeding. That's a conditional relevance problem. You have to prove some other fact. What would be that other fact that you would argue to make it conditionally relevant? The driver was at ease. Well, maybe. Well, that's something that same conditions applied, right? That same conditions applied. What about this sexual abuse example? I prove that this child sexually victimizes others, and I say that's logically relevant to prove that she herself was abused. How might you question on conditional relevance grounds the applicability of the logical relevance standard? You want to think about that. What other facts might you need to know about the child in order to conclude that this is in fact evidence that she was sexually abused? Yeah. Mm-hmm. Yeah, so you have a temporal thing. So you can say, well, when did she do this? Well, let's say she did this years and years ago before you even alleged that the sexual abuse occurred. Well, there's no way that it was caused by the sexual abuse, so there's no way it can be evidence of sexual abuse. So you'd have a temporal question. You could ask specific things about the kind of victimization. Well, wait a minute. Did the study say that this particular kind of victimization leads to an indication of sex abuse? Or is there something more specific? So always think, is there something more specific you can ask about the evidence that undermines its potential logical relevance? And if you can package that and present that to the judge as a serious doubt, you can turn a logical relevance issue into a conditional relevance issue. Now, so what? Right? So what? Well, notice that if the judge under 104A says it's logically relevant, all the judge does is say, commonsensically, the evidence increases the likelihood of this supported conclusion, and I'm going to let it go. But what is the additional step that's required if you turn it into a conditional relevance problem? What is the additional step that's required? What's the additional step? If you can say it's not just logical relevance, it's conditional relevance, therefore, the other side has to, yeah. That's right, they have to prove that precondition. I'm sorry to kind of Maybe it's so obvious, didn't want to say it, but thank you, to drag it out of you. But they have to prove that precondition. Now, the standard is not that they have to prove it to the satisfaction of the judge. They don't have to convince the judge. So it's kind of tricky. Logical relevance, the judge just uses his or her common sense. Once it becomes a conditional relevance question, now there has to be additional relevance. There has to be, additional evidence to make that conditional relevance claim. And the language of the rule says, oh no, I don't want to show you that yet. The language of the rule says, let me skip to the next slide, and then we'll come back to this slide, because this is a different point. The language says, the introduction of evidence sufficient to support a finding. Now, what does that mean? Sufficient to support a finding. Under logical relevance, the judge has to be convinced. Once it becomes a conditional relevance issue, notice that you have to have admissible evidence, right? The judge can't consider anything from conditional relevance. It has to be admissible evidence, and it has to be sufficient to support a finding. And what that means is now the judge says, could a juror reasonably conclude that the precondition is true? Okay? So, logical relevance, common sense, judge has to be convinced. Conditional relevance, additional evidence has to be produced. Judge has to find sufficient to support a finding. Now, is this standard, sufficient to support a finding, is this more tough or less tough than the standard that you have to convince the judge? Another way of saying this is, under this standard, does the judge have to be convinced of the precondition? Just give me head nods or no. No. So this is a more lenient standard. So you can say in some ways conditional relevance is tougher than logical relevance, right? It's tougher because you have to produce admissible evidence to satisfy the precondition. But then when the judge decides whether to let it in, the judge adopts a more lenient standard. The judge says, I don't have to be convinced of the conditional relevance. I only have to find that a reasonable juror could conclude that this is true. And this may be the difference then between Romano and 104B. What the court seemed to do in Romano is say, I'm not convinced that the bike remained in the same condition. And you could say that under 104B, that was too strict a standard. The judge should have said, well, could a jury reasonably conclude? And if you think about it, a juror reasonably concluding, they could conclude most anything, right? Unless it's totally implausible that this bike remained in the same condition, I should let it in. And notice that letting it in means the jury gets to hear everything. The opponent can still argue the conditions are not met. The jury can still hear about Costarus and the bike being in storage, but it becomes an issue for the jury. And of course, this is what the plaintiffs want, right? Why do you suppose you've got a sympathetic 7-year-old with a fractured skull against a big company and a directed verdict for the defendant? Is the plaintiff always wants the jury to hear. They know that the jury will be sympathetic. The jury will find for a little girl, even if there's not clear evidence of liability. The company knows that too, and they're afraid of it, and they want the judge to exercise control. And so it's the classic battle between the judge and the jury, sympathies for the poor plaintiff and the big corporation. It's the same old, who is it? That little guy in Goliath. Same old story. Yeah, thanks, David. Can't believe I couldn't remember that. Okay, this is the little piece that I skipped over. Why does the rule say the court shall admit the evidence upon or subject to evidence supporting the precondition? And the reason why it uses this language is that the court can admit the evidence subject to a motion to strike if the precondition is not supported by subsequent evidence. Why would the judge do this? Right? Why would the judge allow it in? So the issue would be, Mundell is up there on the stand. He's ready to testify. The plaintiffs say, okay, can you tell us about the condition of the bike? Objection, conditional relevance. We don't know if the bike was in the same condition. When would the judge say, I'm going to allow this subject to a motion to strike? When would the judge say, no, I'm going to only allow this after you've proven the bike was in the same condition. In other words, when would the judge use the subject to language? Would he use it when he or she was convinced that the condition was likely to be met or not likely to be met? Thinking. I know the forced choice question is scary because there's a 50% chance of getting it wrong, right? Yeah. Yeah. Right. And why is that? Yeah. Right. Right. It hurts the story, so there's that order of proof thing. It creates an inconvenience. Mandel, he's a paid expert witness. He's going to have to come back out, maybe fly back out. And if the judge is convinced that it is going to be connected up, what does the judge not worry about then in allowing Mandel to proceed? Yeah, because if the judge is really worried that there is a conditional relevance problem, but the judge lets the jury hear the expert saying the brake was defective, the jury may not be able to disregard that later. So if the judge thinks there's a really good chance that he or she is going to have to strike that testimony, then no, don't allow the expert to continue, make it a precondition. But if the judge is satisfied that that's going to be connected up, I'm not going to worry about it. The judge doesn't have to worry about prejudicing the jury, and the interests of allowing the party to get their order of proof, allowing the, expedient justice, the wheels of justice to proceed outweigh. And that's why the judge would make that decision. Okay? Okay, excellent. All right, so we already did this one. Now let me get you ready for prejudice, which will start, I guess this is just a one-day week. It's kind of weird, isn't it? So we'll do this next Monday. We're going to talk about prejudice. And this is issues where the jury will misweigh evidence or use evidence for the wrong purpose. But hopefully what the discussion of sexual abuse allows you to do is to think about how you argue issues of logical relevance, right? Notice that when we said abused kids have this symptom, you now know that you must ask, do non-abused kids have this symptom? Well, another way to think about this is that if somebody says, this is something a guilty person does, the natural instinct on the defense's part should be, well, is this something an innocent person does? And you want to spin out possibilities for why innocent people do the same thing as guilty people. And the more likely it is that innocent people do the same as guilty people, the less probative value the evidence has, right? So it may be something that guilty people always do, but if it's something that innocent people almost always do, then the evidence has less probative value, right? So when you read, and we talk about prejudice next week, that the courts assume that flight implies guilt, the reason why flight implies guilt is because guilty people flee, right? If you're guilty, you run away. Police knock on the door, you don't go and answer it. You're not a fool, right? But in order to understand logical relevance, you say, well, flight might not imply guilt because innocent people might flee too. And here's where the logical relevance based on common sense leads you to sort of understand the problems that sometimes exist, right? Common sense is the common sense of the judge. And the judge has a certain upbringing, has lived in a certain neighborhood, with certain attitudes about police, right? It may be the case, though, that the defendant who has fled from the scene of the crime upon seeing the police has a different background, has a different mindset when it comes to understanding the actions of police. And if that's true, then there may be lots of reasons why an innocent person in the defendant's shoes would not stay around, would flee even if he were innocent. But because the judge adopts a logical relevance standard which only appeals to common sense, the judge doesn't consider any other evidence. But what you can do with conditional relevance is you can say conditional relevance is a way that you can get the judge not to rely on common sense, but to think about maybe differences in background that would suggest innocent reasons for the defendant's behavior. Okay? So conditional relevance is a tool not just for arguing that specific facts need to be included for logical relevance purposes, but it's also a tool for getting the courts to overcome their common sense, their prejudices and biases about different groups of people that may be based on their own lack of understanding of the specifics of the defendant's situation. Okay, my clicker man is here. Rick, why don't you go ahead and come in? And do you want to take over and explain to the class how we're going to distribute? We can stop the taping at this point. Oh, okay. Okay. Yeah, we're ready. We're ready, because I was able to end a little early.